seated.
All right, we're on the record in the matter of the state of Florida versus Chad Absher. I'm told the jury has reached a verdict. Any reason we can't go ahead and bring the jury out at this time?
Your Honor, we're just trying to find our family. If we don't mind waiting just a few more minutes, just trying to reach out to them. So
Okay.
figure out where they are. You sure? You sure? Okay. Well, then, Your Honor, I see no reason why we can't proceed.
All right, then let us bring out the jury, please. All right, you all may have a seat. All right, Mr. Carlson, are you the foreperson, sir?
Yes, ma'am.
And has your jury reached a verdict?
Yes, I am.
Can you please hand the verdict forms over to Madam Bailiff? All right, the court finds that there are no errors or omissions in the filling out of the verdict form. Madam Clerk, can you please publish the verdicts?
In the Circuit Court of the 4th Judicial Circuit in and for Duval County, Florida, case number 16-2017 CF 9954-AXXXMA, State of Florida versus Chad Absher. As to count 1, we the jury find the defendant guilty of first-degree murder as charged in the indictment. We further find the killing was premeditated. We further find the killing was done during the commission or attempted commission of a felony, to wit, attempted first-degree premeditated murder. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. As to count 2, we the jury find the defendant guilty of attempted first-degree premeditated murder as charged in the indictment. We find the defendant discharged a firearm causing death or great bodily harm during the commission of the offense. Still say we all done at Jacksonville, Duval County, Florida, signed by the foreperson on November 3rd, 2022.
Does counsel for either the state or defense desire the jury to be polled?
Yes, Your Honor.
Okay, Madam Clerk, if you can please poll each juror.
Yes, Judge.
Thank you. All right, then Mr. Absher, if you'll come forward for sentencing, sir. All right, Mr. Absher, I of course sat through the week-long trial in your case. I also have listened today to the testimony of witnesses, listened to some letters that were read into the record, and have considered the arguments of both of the attorneys. Let me say just a couple words before I impose sentence here. I've been on the bench now approximately 10 years, and I have sat in a variety of different kinds of trials in a variety of different facts and circumstances. But I look at each case and each person individually. And the facts and circumstances of this case were by all accounts horrifying. The fact that this happened in front of these 2 young children who are forever going to be traumatized is a fact that I'm not taking lightly. And to me, in this case, is an aggravating factor. I don't think Ms. Rucker and your family will ever have closure. I don't expect you to, but hopefully with today's sentencing, there will be some sense of closure. And I certainly hope and encourage, if your son Colton and if Joseph in New Jersey is undergoing counseling and therapy for this event, that they certainly continue to do so in the hopes of perhaps leading as normal a life as they can in the future, especially Joseph without his mother. And I certainly hope for all of you that the good memories, the wonderful memories that you have of Ashlee can provide you at least some comfort in your grief as you go forward with your life from this point forward. But no sentence I impose today is ever going to bring her back. or will ever, I suspect, satisfy anybody. But I will impose the sentence I think is appropriate and that is within the bounds of the law. So with that, Mr. Absher, as to counts 1 through 3, the jury having found you guilty on each of counts 1 and 2, and you having pled guilty, a plea I accepted as to count 3, I'm now going to adjudicate you guilty of each of those 3 counts. On count 1, I will sentence you as the law requires me to mandatory life in prison with no possibility of parole. On count 2, I'm going to sentence you to life in prison. As required, well, not as required, but I feel as appropriate in this matter. As to count 3, I will sentence you to 15 years in prison with the required 3-year minimum mandatory. You will get credit for the 1,855 days that you have already served. Count 3 will run concurrent to count 1 and 2, but count 1 and 2 will run consecutively with each other. That is count 1, then count 2, and count 3 will run concurrent to count 2, or 1, regardless. I will impose mandatory felony court costs of $518. There's a $150 attorney fee lien. Is there any restitution that I must order, or do I need to reserve jurisdiction?
I would ask you to reserve jurisdiction, Your Honor, and I think just also for record purposes for count 1, would that include also the mandatory life in the 1020 life?
1020 life, both on count 1 and on count 2.
Oh, okay, yes,
The
so,
jury found that the defendant actually possessed
Correct.
a discharge of firearm with death or great bodily harm.
thank you, Your Honor.
So those minimum mandatories are applicable based on the jury's findings. I believe that is all. Do you understand your sentences?
Yes, ma'am.
Now, you do maintain the right to appeal, of course, both the judgments and the sentences. You must do so by filing a notice of appeal within the time so designated to the clerk of court. Would you like an attorney appointed to represent you on appeal?
Yes, ma'am.
All right, then at this time I'll appoint an attorney for purposes of appeal. And that, sir, will conclude this matter today. Thank you very much.